Hi, everyone. Thanks for joining us for our third webinar on telecommunications and technology. If you missed our previous webinars, you can find the recordings and presentations on our website at bit.ly/AAJC-hub. Our first telecommunications and technology webinar discussed future of work issues, and our second webinar covered digital inclusion and literacy. And today's webinar will be focused on social media surveillance as an immigration vetting tool. You can find additional information on these topics at our Community Resource Hub, which includes backgrounders, blogs, advocacy letters, and more. So, what is social media surveillance, and what are the most prevalent applications in society? How is the federal government using social media surveillance as an immigration vetting tool? What is Doc Society versus Pompeo? These questions will be explored in this webinar. And this webinar is recorded, and we'll be sending out the recording and a copy of the presentation after the webinar. We will have Q&A at the end, and you can use the chat box or questions box to send your questions, or raise your hand to have your line unmuted so you can ask the question yourself. If you have any questions during the presentation, please also use the chat box or the questions box to send us your questions. And I'll also repeat these instructions once we get to Q&A. So without further ado, I want to turn it over to our speakers. Today's webinar will be moderated by Livia Luan, who is the Programs Associate and Executive Assistant at Asian Americans Advancing Justice, AAJC. She advances the organization's policy and advocacy work by providing high-level support to the telecommunications, technology, and media program. She conducts research, develops community education materials, and engages in legislative and administrative advocacy on issues such as privacy, digital equity, and internet surveillance. And we're joined today by three amazing colleagues in the telecommunications and technology, immigration, and civil rights space. I'm pleased to introduce Rachel Levinson-Waldman, who serves as Senior Counsel to the Brennan Center's Liberty and National Security Program, which seeks to advance effective national security policies that respect constitutional values and the rule of law. Rachel is active on matters at the intersection of national security and law enforcement, technology, and civil liberties and civil rights. She writes and provides commentary on issues including the federal government's use of surveillance technologies and information collection in the immigration context, as well as law enforcement access to social media, predictive policing, body cameras, license plate readers, and other types of surveillance technologies deployed in public. We're also joined by Gisela Perez Kusakawa, who is the 2019 to 2021 National Asian Pacific American Bar Association Law Foundation Community Law Fellow at Asian Americans Advancing Justice, AAJC. She advocates in Congress and federal agencies to challenge the ongoing criminalization of Asian Americans and immigrants. As part of her fellowship, she addresses issues such as the surveillance of Arab, Middle Eastern, Muslim, and South Asian communities and the targeting of Chinese scientists, researchers, and students. And lastly, we're joined by Javeria Jamil, who is the staff attorney with the National Security and Civil Rights Program at Asian Americans Advancing Justice, Asian Law Caucus. She works at the intersection of matters involving national security, law enforcement, and immigration policies. In this role, she provides direct representation to impacted communities and individuals and advocates for policies that protect Arab, Middle Eastern, Muslim, and South Asian communities at the local and state level. Without further ado, I will turn it over to Livia.
Thank you, Bessie, for those introductions, and good afternoon, everyone. In recent years, school districts, police departments, and federal agencies have used social media to monitor individuals who are deemed potential security threats. Social media accounts are scanned with the expectation that they might reveal their subjects' intention to partake in criminal or terrorist activity. Although the surveillance efforts of school districts and police departments are worth deeper investigation, today's webinar will examine the federal government's deployment of social media surveillance to vet immigrants and foreign travelers seeking to respectively settle in or visit the United States. As our speakers will later explain, both the U.S. Department of State and the U.S. Department of Homeland Security have issued proposals and promulgated policies that allow them to monitor social media accounts associated with millions of individuals. These actions are invasive and discriminatory, inflicting disproportionate harm on communities of color and religious minorities. Next slide, please. We are so excited to partner with Spectrum for this webinar, which represents the third and final installment of our webinar series on critical telecommunications and technology issues that impact Asian Americans and Pacific Islanders, along with other vulnerable communities. Our first webinar on the future of work examined how automation has affected and will continue to affect Asian Americans and Pacific Islanders in different sectors of the workforce. Our second webinar on digital inclusion and literacy analyzed how low-income community members are harmed by the digital divide and highlighted a number of advocacy and community engagement strategies. Today's webinar will focus on the civil rights and civil liberties implications of the federal government's social media surveillance policies, while featuring the perspectives of speakers who advocate on behalf of communities of color and religious minorities impacted by such policies. Whether you are a direct service provider, a policy advocate, or a litigator, we hope that this webinar can help you identify a few concrete ways in which you can serve and empower the communities at the center of this issue. Without further ado, I want to start our program by welcoming Rachel Levinson-Waldman from the Brennan Center for Justice. Go ahead, Rachel.
Great, thank you so much for having me. I'm really glad to be part of this discussion. I think it's a really important one. So I want to start off by talking about sort of the history of the development of social media monitoring. You can go to the next slide. And in particular, the use of social media monitoring for immigration and visa vetting purposes. And while it's gotten a great deal of attention under Trump, and quite rightly so, its use has really been magnified and kind of weaponized in this period, it actually dates to the last part of the Obama administration. And so that's where I want to start, so we can kind of map out what's happened and where we are. I think it's useful in terms of seeing the breadth and scope of use of social media for these purposes. Next slide. So starting in late 2015, so in the last year of the Obama administration, DHS, Department of Homeland Security, implemented several pilot programs. They were non-public at the time, that tested out manual and automatic screening of social media accounts of a limited number of people who were applying to travel to the United States. And the goal of these programs was to, as DHS and as the department's Inspector General said, to examine the feasibility of using social media screening with an automated search tool. So that was one of the reasons this was a big step, was not just looking at social media, but trying out different automated search tools that would find information the department thought would be helpful and analyze it. This became public in early 2017 when the DHS Inspector General released a report that found that DHS just hadn't set out adequate benchmarks to evaluate whether the programs worked. They weren't adequately measuring or evaluating the results. So it was kind of impossible to tell how well those programs had worked, if at all. Next slide. That said, in the summer and fall of 2016, so this is very near the end of the Obama administration, DHS issued a new proposal. This one was optional, and the idea was that DHS would begin collecting social media identifiers, so basically handles on a variety of social media platforms, from travelers coming from the visa waiver program countries. So that's primarily Western Europe, parts of Eastern Europe, and Japan, South Korea, and Taiwan, in addition to, for instance, Australia, New Zealand, and a couple of other countries. And so the idea with that program is that if you're traveling from one of those countries, you don't have to apply for a visa, but you still go through this online process, and DHS vets sort of some basic information. So DHS said, okay, we are now going to add as an item on the form that people fill out, an optional field for social media handles. Brennan Center, a number of other organizations submitted comments in opposition to this, arguing, and I'll talk about this in a little more detail a little later, but saying, you know, it's vague, it's not clear if people have to comply, this information is going to be used pretextually, social media is incredibly hard to interpret, and especially when you're looking at multiple languages, lingo, cultural background, it's likely to chill speech. And it also wasn't clear if people were ultimately going to be punished for not filling it out or filling out only part of it, even though it was supposed to be optional. But despite a lot of opposition to this plan, it was implemented in December 2016. And that really represented a pretty significant expansion, even though it was just the visa waiver program countries and just this optional collection. It turned out to be the beginning of really a long push to collect more and more social media information as part of immigration and visa vetting. Next slide, please. So, of course, in January 2017, President Trump was inaugurated, and he issued an executive order that became known as the first Muslim ban. Although this particular order was withdrawn, of course, the Muslim ban is still with us. They just sort of tinkered until they got to one that would pass muster, and the language lived on. I'm not going to go into this in a lot of detail, since I think this is something that Javeria will be talking about in more depth. But among other things, this executive order required all travelers to the US to be screened to determine if they would be positively contributing members of society, and if they would make contributions to the national interest. That's all language from that executive order. And also if they intended to commit a crime or a terrorist act. And this order directed the Departments of State and Homeland Security to take steps to implement what was supposed to be this new screening process. Next slide, please. So in May 2017, the Department of State took the first steps towards doing exactly this, implementing its part of the screening process, when it issued an emergency notice saying that it, the State Department, intended to request social media handles in order to help resolve the identity of a visa applicant, or to, quote, vet for terrorism or other national security related visa ineligibilities, when a State Department officer at a consular post or somewhere around the world determined that the circumstances of that visa applicant, review of the application, or the responses in a visa interview suggested that there was a need for greater scrutiny. So again, the Brennan Center and a number of other organizations submitted comments in opposition to this proposal, again, citing many of the same concerns and noting that this came directly out of the Muslim ban. And we knew that the Muslim ban, whatever it was called and however it was couched, really was a fundamentally anti-Muslim order. And so in addition to all of our usual concerns and everyone's usual concerns about social media monitoring, there's also the real concern about what had animated this particular language and where it came from. But nevertheless, that emergency collection went into place that fall. Next slide, please. So that summer, there was then a proposal that really caught our eye. So again, using the language from the original Muslim ban, ICE, Immigration and Customs Enforcement, an arm of DHS, put out a request for information, asking if there was a vendor that could build a machine learning system that would automate the process of determining whether an immigrant or somebody who is applying for immigration would make a positive contribution to society or commit a criminal or terrorist act. So again, drawing on this Muslim ban and really looking towards the automation piece of it and using this language about evaluating whether somebody is going to make a positive contribution to society. And ICE wanted to use this system to flag a minimum of 10,000 people a year for deportation investigations or visa denial, and it wanted to award the contract by the following fall, so by September of 2018. A huge number of groups mobilized in opposition to this proposal. It was called the Extreme Vetting Initiative by ICE. And in November of that year, so November of 2017, about nearly 60 NGOs and over 50 experts in machine learning and automated decision-making sent a letter to DHS to tell the department that this kind of program was driven by animus, it would chill speech, it would disproportionately impact Muslim travelers, It would be a pretext for any number of discriminatory decisions, and it simply wouldn't work. You can't build an automated system to make determinations about who would contribute to society or commit an extremely rare act like terrorism. Next slide, please. Luckily, after a lot of concerted advocacy, DHS actually did back down. And so ICE announced in the spring of 2018 that it was no longer going to try to build this kind of automated software, although it did say it was going to continue the program using human reviewers instead. And as far as we know, that program is still in place, called the Visa Lifecycle Vetting Initiative. Next slide, please. At around that same time, so again, in the spring of 2018, the State Department announced that it planned to collect social media identifiers from applicants for both immigrant and non-immigrant visas. And this wouldn't be the optional collection, right, that DHS had implemented in 2016. This was more of the mandatory collection that the State Department had rolled out the previous year on an emergency basis, and now is trying to solidify. Once the proposal was approved, they would ask all applicants, so applicants for any immigrant or non-immigrant visas, so expanding the size of the program as well, would ask all of those applicants for any social media handles they had used in the previous 5 years, along with some other information like address information going back a ways and travel information as well. That proposal, which ultimately went into place in May 2019, is estimated to affect nearly 15 million people per year who have to provide their social media information. Next slide, please. That same month, so the same time that the State Department's program went into place in May of 2019, about a year ago, the Brennan Center published a report that we had been working on for the previous couple of years, really digging into the use of social media for a variety of purposes, for immigration and visa vetting, for investigations, for other purposes, by especially focusing on Department of Homeland Security, but Department of State as well. And this is on our website for anyone who's interested, and I'm happy to also send it out directly. And this really sort of pulled on a lot of different threads about the use of social media. And I'll just briefly highlight, it's a long report, it's a fairly dense report. There were some sort of, high line takeaways that we pulled out that I want to emphasize. So the first is that social media information is collected from travelers even when they're not suspected of any connection to illegal activity, and that could include from Americans. That social media checks extended to travelers' family, friends, business associates, and social media contacts. The DHS often use social media information for vague and open-ended evaluations that could be used to target unpopular views or populations. The DHS was continually monitoring people inside the United States and planned to expand those efforts that related to the Visa Lifecycle Vetting Initiative. That DHS was increasingly seeking and using automated tools to analyze social media. That social media information collected for one purpose was used by DHS in a range of other contexts, which really amplified the risk of misinterpretation. That social media information collected by DHS is shared with other law enforcement and security agencies under pretty broad standards, and that DHS systems retained the information for long periods, sometimes even in violation of their own rules around retention. Next slide, please. And these tied into our concerns more generally about the use of social media, which I've already touched on briefly. And as I mentioned, we and many other organizations, including those on this call, have told Department of State and DHS about these in a whole variety of contexts, but that social media is very subject to interpretation, that'll sweep in information about American friends and family, likely to chill speech. We know they're going to have a disparate impact on Muslim populations, and that there is little to no proven security benefit, even after all this time, especially when you're talking about dragnet social media collection. So not necessarily an individual need to, disentangle an identity question, but this really, really broad collection. And finally, I just want to briefly touch on two recent developments. Next slide, please. So in September of just this past year, September of 2019, DHS issued a proposal to collect social media information from applicants for immigration benefits, including adjustment of status, naturalization, asylum status, and the visa waiver program applicants. So this was shifting from this optional collection that they rolled out in the fall of 2016 to what will be a mandatory collection if and when it's approved, which we expect it will be. This was a really significant expansion, and it's estimated to affect 33 million people per year. And then finally, last slide, please. Just in December, the Brennan Center, together with the Knight First Amendment Institute at Columbia University and the law firm Simpson Thacher, filed a lawsuit against the State Department and Department of Homeland Security. So this is challenging the State Department's dragnet collection of social media handles. So we've been talking about this, sort of expanded over the last several years, as well as DHS's long-term retention and dissemination of that information. And we filed it on behalf of 2 US-based organizations that collaborate with filmmakers around the world, called Doc Society and the International Documentary Association. And it especially highlights the First Amendment harms coming from these policies. So I'll stop there. I'm looking forward to the further discussion.
Thank you so much for your insightful presentation, Rachel. I would like to now turn it over to Gisela Perez Kusakawa from Asian Americans Advancing Justice, AAJC.
Thank you, Rachel, for that wonderful presentation, and Bessie and Livia for the introduction. Here at Asian Americans Advancing Justice, AAJC, we work to advance civil and human rights for Asian Americans and to build and promote a fair and equitable society for all. We know that Asian Americans are now the fastest growing racial group in the United States. As such, it is important that our voice is heard, especially on issues that impact our communities, such as the surveillance of Asian Americans. We have been deeply concerned with escalated efforts by the federal government to monitor the social media accounts of immigrants and non-immigrants seeking to enter the United States. In the last few years, we have witnessed a dramatic rise of social media surveillance for immigration vetting purposes. As my colleague mentioned, this practice is ineffective with little to no proven security benefit, chills free speech, and has a disparate impact on our communities. Next slide, please. In terms of the impact on Asian Americans and immigrants as a whole, I want to take a step back to look at the historical context. The United States government has had a long history of profiling and targeting Asian Americans and immigrants as economic and national security threats. Next slide. From the Chinese Exclusion Act of 1882 to the incarceration of Japanese Americans during World War II, the surveillance and profiling of Muslim and South Asian Americans, and to the wrongful prosecutions of Wen-Ho Lee, Xiaoxing Shi, Sherry Chen, Guo Qingzao, and Shuyu Li, AAPIs are living in the midst of the latest wave of resurgent xenophobia. Next slide. Starting with the Chinese Exclusion Act of 1882, which halted Chinese immigration for over 60 years and prohibited Chinese people already living in the country from gaining citizenship. We see this followed by a series of exclusionary and discriminatory laws upheld by the Supreme Court. The Scott Act of 1888 excluded all persons of the Chinese race, including those with legal status. This was challenged in the infamous case of Chow Chang-ping versus United States. This challenge failed as the Supreme Court upheld the discriminatory law. This would prove not to be the last of the Supreme Court upholding laws that discriminate and target Asian Americans and immigrants. Chinese exclusionary laws paved the way for future immigration laws rooted in anti-Asian sentiment. These exclusionary laws, fueled by xenophobia, effectively changed the face of America. As a result, by 1960, there were only under 1 million Asian Americans in the United States. That was a mere half of 1% of the American population. During World War II, US military leaders without cause feared that American citizens of Japanese descent would execute acts of sabotage against the government. President Roosevelt issued Executive Order 9066, incarcerating approximately 120,000 Japanese Americans, half of whom were children without any trial or representation. The human impact of this blanket incarceration of Japanese Americans was tremendous. Over 5,000 American babies were born in detention. About 2,000 people died in incarceration from a series of causes, including infectious diseases, bad sanitation, or even shooting by guards. Like in Chao Changping, ordinary individuals stood up to challenge what was an unjust law. Fred T. Korematsu challenged the constitutionality of the executive order, but the Supreme Court held that his imprisonment was constitutional and that the government action was justified as a military necessity. We then see the Immigration and Nationality Act of 1965, or the INA, which terminated the previous exclusionary and discriminatory laws that barred and limited Asian immigrants from coming to the US. From its inception, the INA was meant to reform discriminatory immigration practices and laws that targeted individuals, particularly those from Asia. Next slide. My colleague Javeria will discuss the profiling, surveillance, and criminalization that Arab, Middle Eastern, Muslim, and South Asian AMEMSA communities face under the US government post 9/11, as well as the CVE program. We recently saw the Supreme Court make another dark stain in history with their decision to uphold the Muslim ban, while simultaneously overturning Korematsu versus the United States. On January 31, 2020, President Trump then expanded the Muslim ban to 6 additional nations, which Javeria will delve deeper into. We then saw a string of wrongful prosecutions of Chinese scientists raising concerns of the presence of implicit bias, discrimination, and race and ethnicity-based profiling in these investigations. One case includes Chinese-American hydrologist Sherry Chen, who was accused of espionage by the FBI. Despite her case being dropped and there being no evidence of espionage, she suffered harm to her reputation and lost her livelihood. Next slide. The legacy of targeting and scapegoating Asian Americans continues to this day. From the Muslim, refugee, African, and immigration ban to the separation of Latino children from their parents and wall construction on our southern border, we're experiencing a resurgence of white supremacy and heightened racism in the US. Like the targeting of AMEMSA communities, the rise of anti-Asian and anti-Chinese sentiment predates this administration. The current social and political environment has created fear among our communities as rhetoric from public leaders, including the director of the FBI, encourages bias and fosters hate against Asian Americans and others of Asian descent. Next slide. We've seen a series of extreme immigration vetting policies, which Rachel provided a terrific timeline for. We have seen an uptick in xenophobic rhetoric and in the government's efforts to target Chinese and Asian Americans and immigrants for espionage-related claims. As the government increases efforts against Chinese espionage, more innocent defendants of Asian heritage, including Americans, will be arrested and then prosecuted, or even if they are not prosecuted, suffer irreparable harm like Sherry Chen. This latest wave of xenophobia reverberates through our intelligence and enforcement community, with technology as being the new avenue and tool for discrimination. Next slide. We have seen a series of extreme immigration vetting policies, which, as I mentioned, Rachel provided a terrific timeline for. One of these efforts included the CBP's proposal to collect social media identifiers, specifically from Chinese visa holders for vetting purposes. Chinese nationals with B1, B2, and B1, B2 visas were singled out as individuals from other countries with the same visas were not subject to the same heightened information collection. This impacted not only the visa holder, but also their US citizen and LPR family members whose information and privacy would be impacted as the social media information of the visitor is collected. We oppose this proposal because it would lead to increasing profile based on race and would continue to fuel historical anti-Chinese and anti-Asian sentiment. Advancing justice, AAJC cautions against any discriminatory policies that treat individuals differently based on their race or ethnicity, or continues the historical scapegoating of those of Asian descent. This concern is particularly relevant today as we see a rise in anti-Asian and anti-Chinese sentiment as a result of COVID-19 and biased rhetoric by public officials. Next slide. We have also seen some concerning reports, such as CBP's detainment and denial of admissions of 9 ASU students from China. Arizona State University had criticized CBP's lack of transparency with why the students were detained and denied entry. Moreover, the university had rejected any reports of academic dishonesty as the reason for the students' denial, considering that they would be in the best place to make that determination. The incident with the 9 ASU students is not in isolation. In June, a Cornell undergrad was initially denied entry and his student visa was canceled. He was able to get a new visa, but the experience has made him feel unwelcome in the United States, and he remains anonymous out of fear of retribution from the US government. In light of our concerns with the lack of information available and the potential use of social media surveillance against students, we are submitting FOIA requests on the surveillance of AAPIs, including CBP guidance and activities related to the admissibility and social media activity of Chinese and international students, as well as local CVE programs targeting AMEMSA communities. Discriminatory policies targeting those of Asian descent impacts lives, reminiscent of how early exclusionary laws against Asians changed the face of America. These current policies have created an unwelcoming environment, leading to the decrease of international student enrollment, particularly of Chinese students, and an overall chilling effect on our community as a whole. Next slide. We have serious concerns with social media surveillance. First, as DHS agencies gain access to a growing collection of personal information extracted from social media accounts, they may use it to subject religious minorities and communities of color to enhance vetting and surveillance. Second, we see that social media surveillance could also have a chilling effect on online expression, particularly from those in the Muslim communities. Third, the accumulation of personal information at the hands of the federal government raises privacy concerns. This is very concerning in light of the immigration context, considering that the sharing of information between DHS and law enforcement and security agencies would have tremendous implications for immigrants. Next slide. Moving forward, we need to look at surveillance not just in isolation, but as a part of a larger need for immigration reform. We should maintain an immigration system that is true to our American values and spirit as a land of opportunity for all people, regardless of their race, religion, national origin, gender, or educational attainment. We must protect immigrants from discrimination based on religious animus, and we must prevent the abuse of executive power to deny entry to classes of people based on illegitimate reasons. Congress must defund and repeal all iterations of the Muslim ban, including the expanded ban, and prevent any future precedent from enacting any new similar bans. Additionally, Congress should broaden non-discrimination provisions within the Immigration and Nationality Act to add religion to the list of protected classes and to cover all visa applicants, immigrant and non-immigrant alike. Lastly, we oppose the use of social media surveillance and screening to aid in decisions about immigration benefits or visas. Social media information should not be used to determine immigration applications, admissibility, and other crucial immigration decisions. Next slide. Some of our work on this issue includes educating policymakers, impacted persons, and the public, as well as agency oversight and administrative advocacy. We have participated in sign-ons and comments, including a letter and administrative comment this past fall, led by the Brennan Center and other advocacy groups on DHS's proposed rule on social media identifiers. As I mentioned, we are also submitting FOIA requests on the surveillance of AAPIs to make sure the public has access to crucial information on issues that impact our communities. Next slide. Additionally, we encourage you to check out our most recent immigration report, as well as our recent statements on the No Ban Act and the profiling of Chinese and Asian Americans and immigrants. Next slide. If you or someone you know has been impacted by government efforts to scrutinize social media activity for immigration purposes, I encourage you to share your story for advocacy purposes and feel free to contact me at gkusakawa@advancingjustice-aajc.org. Thank you so much for your time, and I turn it back to Livia.
Thank you so much, Gisela. I am now excited to turn it over to our last speaker, Javeria Jamil from Asian Americans Advancing Justice Asian Law Caucus.
Thank you, Livia, and thanks, Bessie, for the introduction, and to my co-panelists for their presentations. So I quickly wanted to just talk about Asian Law Caucus before I delve into my presentation. Asian Americans Advancing Justice Asian Law Caucus is the oldest legal and civil rights organization defending the rights of Asian Pacific American communities. We have 6 program areas: housing rights, workers' rights, voting rights, immigrant rights, criminal justice reform, and national security and civil rights. We have a local to global model and we employ a broad strategy which integrates the provision of legal services with community education, policy advocacy, and litigation. I'm a staff attorney with the National Security and Civil Rights Program, which aims to protect the civil rights of individuals and communities unjustly impacted by overbroad national security policies. Next slide, please. So I wanted to first generally talk about surveillance in AMEMSA communities, not specifically social media surveillance, but largely surveillance in the post 9/11 world. So profiling and unjust surveillance and criminalization of marginalized communities is not new, as evidenced by the experiences of Black Muslims before the September 11th attacks. In the post 9/11 world, what changed is that AMEMSA communities and their actions are increasingly seen through the lens of national security. And oftentimes, actions that otherwise would have gone unnoticed are seen through this hyper-suspicious lens. So I want to briefly talk about a few examples of how the government has used different programs and tools since 9/11 and continues to do so to surveil the Arab, Middle Eastern, Muslim, and South Asian communities, or for short, AMEMSA communities. So soon after 9/11, Congress passed the Patriot Act, which vastly expanded the authorities, the statutes that have national security letters have. So national security letters are basically law enforcement tools used by the FBI to obtain information from private companies such as banks, telecom companies, and internet companies for national security related reasons. They allow the FBI to gather information about individuals without getting a warrant from a judge. In the first 10 years of their use after 9/11, according to both the Electronic Frontier Foundation and the ACLU, the use of national security letters resulted in 1 terrorism conviction. Compare that to about 200,000 national security letters that were issued, allowing the federal government to gather infinite data on both American and foreign nationals. Another legacy of the post 9/11 world, which has wreaked havoc on Muslim communities, is the FBI's Joint Terrorism Task Forces, or JTTF. Although the first JTTF was formed a few years before the events of September 11th, their numbers proliferated after the attacks. JTTFs are basically partnerships between the FBI and local and state law enforcement agencies, whereby local officers are cross-deputized as federal agents and carry out the FBI's work. In California, the FBI and the JTTFs after 9/11 worked around the clock, surveilling mosques and other Muslim cultural centers. FBI informants infiltrated mosques, entrapped individuals into carrying out criminal actions that they otherwise would not have even thought up of, and in at least one case, coerced an individual into making a false confession. The JTTF surveillance of Muslims has lasting impacts on both the individual that's surveilled and also the community. Individuals who are surveilled, oftentimes without being suspected of any wrongdoing, can lose their jobs, their reputation in the community, and if they're immigrants, they can face long delays in the adjudication of their immigration petitions and sometimes denial of their immigration petitions just because a JTTF agent opened up a file on them and surveilled them for whatever reason. In terms of communities are fearful of exercising their First Amendment rights and don't want to be involved in mosques beyond going in to pray. For instance, we've heard several stories of individuals in the Bay Area not wanting to join mosque boards because they don't want to be flagged by the FBI. Finally, there is the Countering Violent Extremism, or CVE program, which has most recently been rebranded by the Trump administration as the Targeted Violence and Terrorism Prevention Program. CVE funds grassroots organizations and services to surveil and report on communities. It employs so-called indicators of radicalization and extremism based almost exclusively on cultural, racial, and religious markers of expression. Examples of some indicators include growing a beard, not drinking, not smoking, not going clubbing, or attending a mosque regularly, all of which disproportionately target Muslims. Next slide, please. Social media surveillance is then another tool in the government's arsenal to gather information on and profile certain communities. Like Rachel said, social media surveillance is not new to the Trump administration. And in fact, the Obama administration had started using it as a tool in its second term. However, social media surveillance under the current administration has vastly expanded. I'm not going to go through all the different, collections of social media by the Department of State and DHS, because I know that Rachel just went through that. But I just wanted to say that, just highlight the collection of social media information by the Department of State from every individual applying for any kind of visa to enter the United States. Through our direct services work, we have seen that the government's asking for social media information creates fear and confusion for individuals. I recently received an intake where the government asked for social media information for an 8-year-old trying to immigrate to the United States, which makes no sense, right? What activity can an 8-year-old have engaged in that the government wants information on? What it does do, like I said, is create fear in the communities or in the individuals who are applying for these visas. And it also lets the federal government create databases of information on whole communities, and we have no ways of knowing if this data is how this data is being handled and what the shelf life of this data is. Next slide, please. So as Rachel pointed out, social media surveillance is not reliable for several reasons and specifically impacts Muslim communities. As I've already mentioned, surveillance in general has had a chilling effect on the right to practice religion freely for many Muslim communities who are fearful of being surveilled by the FBI, for example, if they're on a board of a mosque or they frequent a specific mosque too many times. And given how social media surveillance is used both as a tool to bring criminal charges and to vet individual immigration petitions, Muslim communities are increasingly self-censoring what they say and share on social media for fear of how their posts are interpreted. For example, in the Bay Area, in 2018, the FBI arrested and convicted a young man on terrorism charges based partly on evidence gathered through his social media accounts. The community and advocates in the Bay Area largely see the case as an instance of FBI entrapment. However, the case has rattled the community, which the young man belongs to, and parents are increasingly concerned about their children's social media activities. And finally, I wanted to highlight 2 examples of how the government has used social media surveillance to target AMEMSA communities seeking to enter the United States. The first case is pretty famous, I think, at this point, and it's that of Ismail Ajawi, a Palestinian student admitted to Harvard University. When he first tried to enter the United States in August of 2019, CBP officers found him inadmissible and denied him entry. During his questioning at the airport, they asked him about his religious beliefs, and then they searched his laptop and phone. They found posts from a friend of Ajawi's on his Facebook, which expressed anti-US opinions. So to highlight the fact that it wasn't something that he himself had posted, but in fact his friends' posts were the ones that CBP officers questioned him about. The officer questioning Ajavi took issue with the friend's posts and denied Ajavi entry. Ajavi was finally allowed into the US after there was public outcry about the incident. However, the story highlights one of the pitfalls of social media surveillance, where this person was denied entry to the US because someone he knew on Facebook had views that the CBP officer who interviewed him did not agree with, and not because of something that he himself had done. The second case is that of a Pakistani individual whose name is not public knowledge because he wants to keep it confidential. He also tried to enter the United States in 2019. He had been forwarded a message on his WhatsApp, and for all of those on the call who have ever used WhatsApp, and I can speak from my personal perspective, you get a lot of things, especially when you're part of like several different groups, from people that you may not even know, right? So he had been forwarded a message on WhatsApp warning parents in Pakistan about a rash of child abductions. The message contained a picture of a child who had been badly injured by the abductors. And when CBP officers went into his phone, they found only the picture because it had downloaded onto his phone and not the original message. They accused him of organ smuggling, among other things, and refused to accept his explanation, even though the image was readily available online. CBP then denied him entry, revoked his visa, barred him from entering the United States for 5 years, referred him to the FBI's Joint Terrorism Task Force, and even as he was deported, told him that the visa applications for his wife and child, which were still pending at the embassy in Pakistan, would also be cancelled. This incident highlights the hyper-suspicious lens AMEMSA individuals are looked through by the government. Next slide, please. So at ALC, we've engaged in public advocacy around this issue for a while. In coordination with our affiliation, which includes AAJC, in coordination with the Brennan Center, we've submitted comments to the government's proposed rules around social media surveillance, highlighting the impact on AMEMSA communities. In addition, at the local and state level, we continue to advocate against local law enforcement entanglement with the FBI's Joint Terrorism Task Force and against all CVE and CVE-like programming, which are also complicit in surveillance, social media, and otherwise, which in turn have immigration consequences for individuals. A big part of our work is also providing community education. As such, we regularly conduct presentations on securing electronic devices when traveling and the government's use of social media surveillance in general. In fact, we're in the midst of finalizing a community-facing webinar for next week, focusing on digital privacy and social media surveillance. And I'd just like to end by saying that if you or anyone you know has been impacted by the government's effort to surveil their social media, please have them contact us at the Asian Law Caucus. Thank you, and I'll hand it back to Livia.
Thank you so much, Javeria, and thanks again, Rachel and Gisela, for your presentations. Let's move on to our Q&A session, which will be moderated by my colleague, Bessie.
Hi, everyone. A huge thank you to Rachel, Gisela, and Javeria for sharing their knowledge and resources. So we are going to move to Q&A, and during Q&A, you can use the chat box or the questions box to type your questions, or you can raise your hand to have your line unmuted so you can ask the question yourself. And as a reminder, this webinar is recorded, and you will all be receiving the recording as well as a copy of the presentation after the webinar. So I'll give folks a few seconds to enter their questions. And we have one that was submitted via email for the webinar. And so this is a question for all of our presenters. What are your organization's priorities on countering social media surveillance policies, and how can community-based organizations partner with you on your policy advocacy, your research, and your litigation work?
I'm happy to speak to that. This is Rachel from the Brennan Center. I don't want to hop ahead, but I'm happy to share some initial thoughts. In terms of our priorities, in terms of combating social media monitoring, I would say it's in a few veins. One of them certainly is public education. So, the comments that we've submitted, which we make publicly available, the reports that we put out, we have a 2-pager, which I don't think I mentioned, covering how HSI, Homeland Security Investigations, so a kind of half of ICE basically, uses social media for a variety of purposes. So a lot of public education and a lot of Hill education as well. I think certainly in a new administration, one of our main priorities would really be to ask the administration to commit to not using social media in this way. You know, as I mentioned at the beginning of my presentation, it is not the case that these kinds of initiatives are solely implemented under the Trump administration. We know they started under the Obama administration, but I think there's been a lot of awareness that's been built up about sort of how immigration policies and visa vetting policies can be abused and really are abused by targeting them at particular populations, targeting at Muslims and others. And so I think part of our hope is that there would be an opportunity to really do strong advocacy around that. And I'll mention as well, one of the things that we're working on now is a report that would really highlight personal stories. We've done quite a bit of writing around kind of policy and legal issues related to social media monitoring, but I'm working now on a report that would really try to highlight kind of personal stories of what the impact is on people in an immigration context, in law enforcement context, schooling, of being a target of social media monitoring. So I also would really welcome chatting with people who have stories to share or experiences to share.
Yeah, and to follow Rachel's comments, story sharing really is an important part of the work in terms of community education, but also in educating policymakers. At Advancing Justice AAJC, one of our main work is really to be that bridge, to be up here in Washington, D.C., to speak to the ones making policies and laws and to educate them on this issue. In particular, one of our main priorities is really to provide a space and voice for AAPIs who are impacted by this. We are working to get more information on the impact that this has on the Asian American community across the country through FOIA requests, but really in terms of partnership and how we can work with other local organizations, being able to collect stories from Asian Americans or immigrants and nationals who have been impacted, who have had a bad experience, and they can share their story. They don't need to be public with it. They can share their story anonymously, and it can still reach those who are going to be making all these policies and changes that's going to impact their lives. So we really encourage that sort of collaboration with local groups.
Yeah, I think similarly, I think storytelling and sharing your story is the most powerful way to make sure that you know, not just policymakers but the public at large knows what's going on. So I think that's actually the best way that I can think of. And I think in addition to policy advocacy, so when we hear stories and we get intakes from individuals who are affected, it also helps us understand the different patterns, you know, as they're playing out, and can be a basis for future litigation if policy advocacy isn't working. So yeah, I would second both Rachel and Gisela's ask for storytelling.
Thank you. We have a question for you, Javeria. Can you tell us a little bit more about the presentation next week that you mentioned and how people can find out more information about it?
Yeah, we're partnering with the Electronic Frontier Foundation and CARE California to do a webinar. It's community facing, right? So it's meant to be educated for the community and to give them, you know, as much know your rights information as we can in this arena. It's going to be happening on May 6th, I believe. We're still waiting on the marketing materials to get finalized, but happy to share that with folks once I have that.
Thank you. And a question for both Gisela and Javeria. How did Advancing Justice learn that people's social media accounts were being monitored?
Hi, so I mean, a lot of the stories, including the one that Javeria had mentioned about Ishmael, these stories are public. But one of our main problems has really been the lack of transparency from CBP. When we see that students or other individuals are being denied entry into the United States, we don't often get the reasoning for why, and that's really the reason why the FOIA requests and other pushes from local organizations and national organizations is so important, because otherwise a lot of these stories will be swept under the rug.
Yeah, for ALC, I mean, in addition to the public stories that I talked about, we also have clients who are impacted by the Muslim ban, for example. So very early on, we started seeing when the Department of State started asking for social media information from impacted folks. So that was one way. We also work with a lot of different partner organizations that are in the community who are getting, intakes around different issues, and a lot of it, both in terms of immigration, but also law enforcement, implicates social media surveillance. So I think it's a combination of both what's out in the public, but also what we're seeing as part of our work, both as ALC, but also as part of different coalitions.
Thank you. And a question for Rachel, is there any evidence that the government is monitoring Zoom or other platforms to target the work of civil liberties and immigrant rights advocates?
Yeah, that's a good question. I haven't seen evidence of that. I know that there are real concerns, I think legitimate concerns about security on Zoom. There have been reports about things like Zoom bombing, right, and the ways that the platform is vulnerable to people, sort of taking it over, whether to watch a meeting in process or actually interfere with it. I can't say that I have heard reports of the government using it. Never say never, but that's not something that I've seen reports of.
Thank you. And a question for everyone. What are your thoughts on applicants applying for visas deleting ambiguous information on their Facebooks or web pages, or making fake accounts that seem neutral? Or do you have any thoughts on this or concerns, or what would you advise? And also, can the FBI have access to deleted information?
I'm happy to take a first crack at this. I don't want to go ahead of Javeria or Gisela if they had a thought. This is Rachel at the Brennan Center again. I'm sensitive to saying, yes, go ahead and significantly change your social media presence, say just before an interview or something like that. I do think in this environment, I think it would probably be irresponsible not to say to somebody who's considering or applying for a visa, sort of going through a vetting process in some other way, to think seriously about what their social media presence and social media profile looks like. I think it's too bad to have to say, you might want to make it look as sort of anodyne as possible. Realistically, though, I think that's probably the case. I would be very hesitant. I'm not sure exactly what's meant by setting up a fake account. I don't know if the idea is I would have one real account and then I'd have another account under my name and I would only share that handle. I think the problem there is, if a consular officer or if DHS discovers the handle that hasn't been disclosed, I would worry that would be immediate grounds for denial of visa or denial of entry and a longer term bar on entry. But again, Javeria and Gisela may have more to say on that process or advice.
No, that sounds right. Generally, when we do our Know Your Rights, we are having to tell people to, be careful about what they post on social media, not just in the immigration context, but also just generally speaking, because we know how Muslim communities or, generally speaking, AMEMSA communities are looked at from a law enforcement perspective. So yeah, that is advice that we give. And I agree with Rachel. I would not recommend setting up a fake account because it could lead to a denial of the visa application if it was discovered.
Yes, this is Gisela. I agree with Rachel and Javeria on this issue, but the question also really points to one of the concerns that we discussed here in this webinar, which is regarding the chilling effect that this has on online expression, the fact that individuals now are wary and fearful of governmental surveillance, particularly those who have found themselves or their communities to be targeted in the Muslim community or AAPI community at large. So yeah, I share a lot of the cautions and concerns that Rachel and Javeria have, but also the question really forces us advocates and other individuals to really think about ways that we can tackle this so that these are not the sort of questions that regular people are posing on a day-to-day as they just seek to travel and move around here in the United States.
Thank you. And with an eye on the time, we are going to wrap up our webinar. And so I want to share again this community resource hub. And again, we'll be sharing a recording of this webinar, the presentation, and also information for all of the resources our presenters mentioned, including the presentation that Javeria had mentioned taking place next week. And I want to say another huge thank you to all of our speakers today for being on this webinar and sharing all of their knowledge and all this information with all of us. So thank you everyone for joining us today.
Thank you so much.
Thank
Thank
you.
you.